bringing you the latest in tax credit news, insight, and analysis. This is Tax Credit Tuesday with your host, Michael Novogradac.
Hello, I'm Michael Novogradac, and this is Tax Credit Tuesday. This is the December 5th, 2023 podcast. Affordable housing developers, investors, syndicators, property managers, and many more are certainly going to want to listen to this episode. That's because this episode is going to cover the recent release of updates to the National Council of State Housing Agencies of their recommended practices for housing credit administration. As many listeners know, the National Council of State Housing Agencies, NCSHA for short, is a nonprofit, nonpartisan organization that represents the state housing agencies that administer the low-income housing tax credit incentive across the nation. Now, to strengthen housing credit administration, states have developed, through NCSHA, recommended practices in housing credit administration. Now, updates to these recommended practices were released in October. And it had been 6 years since the NCSHA had last updated its recommended practices. Now, the recommended practices aren't binding, but they do represent a consensus among tax credit allocating agencies as to how to administer the low-income housing tax credit. This means that most allocating agencies align the qualified allocation plans with the recommended practices when possible. Now, this latest update does contain multiple important changes. To give a little background on the updates, NCSHA created a task force, 21 executive directors, and then the organization staff members started working on updating the recommended practices. This started last year. Now, a draft of the updated recommended practices was released about 6 months ago, and NCSHA did solicit comments on the draft. That draft included revisions to 23 of the prior 46 recommended practices, as well as including 2 additional proposed recommended practices for a total of 48. Now, among those from whom advice was solicited was Novogradac's Low-Income Housing Tax Credit Working Group. And our working group did, in fact, submit a comment letter on the draft revision of the recommended practices. I can say that the final release, the NCSHA updated practices, does incorporate many of the suggestions of our working group, as well as other commentators. Now, the recently released update revised 23 of the existing 45 recommended practices and did add a new recommended practice covering tenant protections for a total of 46 recommended practices. I will note that one of the proposed additional recommended practices was not included in the recent release. Now, we're not going to cover all the updated, proposed, or added recommended practices, but we are going to focus on 6 of them. The 6 relate to tenant protections, diversity of participants in local tax credit transactions, taxes and bond finance developments, the distinction between development costs of new construction versus act rehab, the IRS Form 8609, and the nonprofit right of first refusal. Now, my guest today, you probably won't be surprised, as you can see, is Mark Shelver. Mark is a housing policy consultant with Novogradac, based in Raleigh, North Carolina, and works extensively with state and local housing credit allocating agencies. We do have a lot of insights to share with you all. So if you're ready, let's get started. Mark, welcome back to Tax Credit Tuesday. I didn't realize that it's been more than 2 years since you're on the podcast. You must have been trying to hide from me.
Indeed. Time kind of lost all meaning post-pandemic.
Isn't that the truth? So before we get started discussing the recommended practices updates, please describe for our listeners the services you provide to Novogradac clients.
So the main focus of my services since joining the firm back in 2015 has been helping state tax credit allocating agencies administer their programs. And I've had the honor to work with roughly a dozen of them since that time, and including starting some rules totally from scratch in a couple of states. Since then, I have also expanded to working even more with local governments. And so I've been helping more of them with their policies and procedures. And so that is the bulk of my practice, but really I'm available for any form of policy consulting advising for anyone who may be interested.
Great. Thank you for that. Now let's get started on maybe the biggest takeaway from the NCHSA's updated recommended practices. And that's the new section, the new practice area, or recommended practice area or section on tenant protections. So tenant protections, that's only 2 words, but it obviously sort of means a lot. So please share with our audience what the recommended practices say about tenant protections. And please give some discussion of how this might affect developers, property managers, or anyone else in the local attached credit community.
So the first aspect of this to consider is the extent to which the agency, in adopting these, applies them to their existing portfolio. So as putting policies into their compliance manual versus putting rules and expectations into their QAP so as to apply to future projects. Now, the way this recommended practice is drafted, it's done carefully so as to allow an agency to comply with the terms of this practice by doing either. And so that's an important thing to be aware of. But what that means is that unlike a lot of what's in these recommended practices, some of these concepts in your state could appear in compliance manual. Therefore, it's not going to be going forward. It's going to apply right now to your existing properties, to the ones that you've been operating for however many years. And this is the one where it's, I would say, the most important to read the actual recommended practice itself, to pull up the file we've got on our website and to read the bullet points. And I won't do that here because that'd be a little dull, but I will mention that they fall into 2 general categories. The first is not something that I think hardly any owner would really mind all that much, which is giving notice. In fact, a lot of owners probably do almost all these things anyway, which is to let tenants know what the screening and admissions processes are, what the fees are going to be, to tell people their fair housing rights, those sorts of things. Again, a lot of owners probably do a lot of that already. And then they do add a couple of new things that maybe don't happen that often, but again, would just be notifications in the event of, say, there's a qualified contract. It would let the owners for the owners to tell the tenants that about the 3-year vacancy decontrol period. Another one that's coming up more and more now as the program matures is to give 12 months notice to tenants for when the 30-year period it terminates for states that have the 30 years and didn't extend that. And so again, those are not big changes or changes at all to the way an owner would run their property. The second category of bullet points in the tenant protection category, though, could be substantial changes depending on the state QAPs and what they've had in place, or the state landlord tenant law, which overlays everything here that applies to all properties. And so these I will mention point for point. The first is a limitation of 1 rent increase per certification period per household. The second is a minimum 60 days notice to tenants of any applicable rent increase. The next, it goes even further, minimum 90 days notice of any rent increase in excess of 5%, with a provision that then allows the tenants to terminate their lease with no penalty if there's going to be the 5% rent increase. So again, those would be, to the extent the state adopted those, especially if they adopted them for existing properties, could be potential substantial changes to the way an owner operated their properties.
Great. Thank you for that, Mark. I did want to note that Stephanie Knockin is our Director of Multifamily Compliance. And many developers or managers or others who just heard what Mark has to say about the tenant protections maybe want to get additional insights, in addition to talking to Mark, reach out to Mark. I'd encourage you to reach out to Stephanie as well. And I'll be sure to include her contact information in the show notes, as well as Mark's. And then it probably goes without saying, but today's show notes will also include a link to these recommended practices. I probably should have mentioned that in my intro. So I think we should now move on to the second of the 6 items, which is about efforts to increase the diversity of participants in local housing tax credit property development, ownership, and operations. So LIHTC has adopted a recommended practice that does seek to bring greater diversity to the community, principally through training or technical assistance, facilitating joint ventures, and providing pre-development capital. So Mark, if you could share what developers and management teams need to know about these recommended practices.
Yes. So these are a part of our society's broader evolution of understanding of the importance of DEI, especially since 2020. And so that having a reflection here in the recommended practice. And it as I read it, the primary function of these new changes to the recommended practices are to remove barriers, to make it so that those who have not historically been participants in our industry are more able to do so. And that seems to be the primary focus of it, to allow their participation. And really and ideally even to go further to encourage it. But it's also important to keep in mind the additional aspect of this that is very clear in these recommended practices, that the idea is that those participants the expectation is that they would actively participate, that they would be part of the development and or management team, that they wouldn't just simply be there in name only, because that doesn't really accomplish the goals. And so I will say, as a drafter of policy, that these types of provisions are difficult to come up with. They're not easy. And there are going to be some states and some agencies that try this in various ways and that maybe don't work out as well as everyone expects. But it's an important goal that everyone agrees we need to advance. And the question is just how and to what extent and in what ways.
Great. Thank you for that, Mark. So the third key item we've highlighted from the recommended practices that we wanted to chat about today has to do with bond finance affordable housing. This part of the practices update reflects a greater understanding of the variations between properties financed with 9% local housing tax credits and those financed with private activity bonds, such that they're generally eligible for 4% credits. And this additional understanding can relate to things such as financing structures, different types of transaction costs, different project sizes, as well as sort of operations risk profile. So some specific instances mentioned in the recommended practices deal with capital budgets and developer fees. So once again, Mark, as I said with the other two, if I'm a developer or investor, what do I need to know about these recommended practices?
So the first step with this recommended practice is to understand its background and history. And what it goes back to is really from almost the beginning of the law when it took place. The interest of allocating agencies and NCSHA was for developers and others to understand and appreciate that bond deals with the 4% credit needed to follow the state's rules, and that the receipt of that resource, the receipt of that federal support came with strings and attachments. In that community, there's some preference to not use the concept of automatic, the idea being that these credits don't just inherently flow. You got to follow the rules that are in the QAP. And so
they're not as of right. Some people call them as of right credits, but they're not as of right credits.
Exactly. It is correct to say non-competitive. That is true. And those all seem very synonymous phrases, but they really are just important distinctions. And so the recommended
even not competitive for the credits.
Exactly.
But you probably are competing for the bonds.
More and more so, absolutely. With each state keeps falling like dominoes in that regard, or improving their circumstance if you see that as a good thing, which you certainly could. And so the recommended practices for many years reflected the agencies and NCSHA's desire to emphasize that point. And so what that resulted in was language that emphasized a need to treat 9% deals and bond deals at 4% credit the same, that you had to have the same kind of rules. And this revision, this new recommended practice reflects what is that is still a goal. That is still an interest of all these parties, but the new recommended practice reflects that with regard to many underwriting aspects, the two types of deals really are importantly different. And so this now it would be an opportunity for developers and other interested parties to go to their agency and say, look, these policies you have as being one and the same, maybe they don't need to be one and the same. And there's support now in the recommended practices to make that point. For example, like developer fee. And a lot of states do have different policies for developer fees, but to the extent that they don't, or maybe they aren't as different as they could be, now this recommended practice provides support for someone going to the agency and saying, look, you can adopt and change your policies and make them a little more different than they were before.
So that actually segues quite nicely into the fourth of the six practices that we're discussing. That has to do with development costs. The recommended practices outline different policies for new construction and renovation or rehabilitation. And rehabilitation versus new construction can also be viewed as a distinction between 9% low-income tax credits and 4% low-income tax credits, with the 9% being allocated oftentimes for new construction and renovation oftentimes being done with productivity bonds such that you're eligible for 4% low-income tax credits subject to all the conditions that we just talked about. So what should developers know about this aspect of the updated NCSHA guidance?
So like with the practice on taxes and bonds, the practice here with development cost has an overarching fundamental purpose, which is to have everyone involved with housing credits to appreciate that the reality is that we all need to be aware of development costs as being a sensitivity point, that regardless of whether it's right or appropriate, there are interests outside of those of us who do the work every day who might look at certain developments and say that's too expensive for affordable housing. Again, right or wrong, that is the reality that we live in. And so the goal is to make certain everyone's appreciative of that, aware of that, and sensitive to that in all aspects of the work that they do. And that's been true since the beginning of the program. That's something that, to harken back to that one of the early directors of the NCSHR, Barbara Thompson, she would emphasize at every opportunity. And so the big change in this recommended practice update, which is something that we put in the working group letter that you referenced earlier, is that while that is an absolutely important goal, it's also important with these policies to reflect that new construction developments are fundamentally different than rehabilitation developments, especially in the context of development costs. With new construction, you can look at two different projects that may be getting built and see, okay, this one costs X $1,000, $100,000 per unit. This one costs Y $100,000 per unit, and X is much more than Y. So that means that first one, arguably, depending on the circumstances, is being inefficient. That they're taking more resources to build the same number of units. And again, that's obviously a gross generalization. There's any number of reasons why they could be different. But with rehabilitation, that same kind of analysis just doesn't even hardly work ever. It's usually if you're doing more rehabilitation, it should be at least because the project needs more rehabilitation. It's in worse shape. There's more systems that you're updating and changing. And so spending more per unit for rehabilitation can not only make sense, it can actually be good. It can be, it means that project, that development was more worthy of receiving an award than the other one that maybe didn't need as much work.
So thank you for that. And I know there was also maybe a discussion, and maybe you could share your thoughts on this about the minimum per unit requirement for renovation not being a barrier to preservation.
Right. And so that has many agencies over the course of time have been increasing that number. And that's an understandable notion. The idea being that if you had, say, no minimum, other than obviously there's a federal minimum, but that's a really low number. I'm not certain. I'm embarrassed to admit what that number is, but I don't know it's really low. I don't know it because it doesn't come into play very often. And so, but if you had nothing other than that federal, then you could have an award, an application that was basically just to fund a flip. So from one to another, and you wouldn't do any more than maybe switch out the carpets or repaint or something. And that's something that in the policy world, that is widely considered to be a waste of resources, that the purpose of doing a rehabilitation transaction is to rehabilitate, is not that, yes, there's the acquisition credit that's necessary, but that's secondary. The purpose is to make the place nicer to live. And if it doesn't need to be made nicer to live, then it doesn't need to get an award. And again, that's the sentiment in most policy circles. And so, and a way to implement that is to have that minimum rehabilitation threshold. And and in many states, it goes up and up. And the response from some has been that number can go too high. And so you can have it to where you have a project that needs to go back to my hypothetical, say X thousand, $10,000 per unit of rehabilitation. But the requirement is Y, and Y is greater than X. So that would mean that the developer's options are either to try to come up with a way to say that it actually is going to cost Y when really it should only cost X. And that's a bad incentive. You don't want people to try to act like a project costs more than it does, or they just don't bring the deal forward and it doesn't happen. And so the question is, where is that correct level? And the idea being with this recommended practice language that it's possible to set that number too high and that you can have projects that do make sense to go forward, but can't because that number is higher than it should be.
Great. Thank you for that. I honestly think of it just from the standpoint that AC rehab, there's the renovation component of it, and there's the preservation, long-term dedication to affordable housing. So there's a balance between the two because they're both goals to renovate and to commit to affordable housing for a long period of time. And it's trying to get the right balance there with what the actual capital needs of the property are. Let's turn now, Mark, to the fifth updated recommended practice. And that's that we want to highlight. And that has to do with the IRS Form 8609. Now, as many listeners know, the 8609 is the IRS form that credit allocating agencies give to property owners that documents the owner's right to claim low-income housing tax credits, subject to ongoing compliance requirements. The revision added the phrase, ideally within 90 days, to when agencies should issue the final LIHTC documentation after they receive a completed cost certification. This is being driven by the IRS desire for property owners to have the 8609s when they start claiming local tax credits. Inserting this ideally within 90 days language is obviously a positive for developers, investors, and the like. But as a practical matter, ideally isn't must and all the rest. So how do you anticipate this phrase affecting tax credit administration?
Well, you make a good point. It may not have much effect in a particular jurisdiction. And that's in some places, that's because they're already doing this. That's the idea of being 90 days. Picking that time period is in part because of, to an extent, already happening again in a good number of agencies. And so it's not as happens in the HR context, you talk about reach goals. The 90 days is not a reach goal. It is meant to reflect what is, again, a fairly widespread practice. I have to admit, I don't know to what extent it's widespread, but that is my understanding it does happen fairly often. And so the question then is, in the jurisdictions where it's not happening to that form of regularity, how much will they pay attention to this and notice it and react to it? And there's really no way to know. It certainly will be a pointer in that direction to say that this needs to take place. And the common point that agency staff make when they have the opportunity, like in private conversations, is the notion of being complete is what's really key. That a lot of times, in their perspective, what the parties doing the submissions and the related folks that are interested in that, like syndicators, will consider the time period to have started upon the first submission of documentation, when in fact that documentation was missing something that was necessary. And so in the agency's mind, that the note when the clock starts was not then. So there's a mismatch in the perspective there as to when that 90 days starts.
Yeah, thank you for that. And I would just say to listeners, this is a notable issue for syndicators, investors, developers, and the like. And we at Novogradac have been encouraging state agencies to issue the 8609 as soon as possible once they have received a complete cost certification, placed in service package, and the rest. And we've also worked with the IRS to try to change some of the IRS rules. We have developed a procedure whereby if the developer or property owner has done all within their power, submitted all the documents to the state agency, and then if they haven't gotten 8609, to still report the tax credits on the tax returns or on the returns of income for partnerships. I encourage you to reach out to our local monthly tax credit working group headed up by Dirk Wallace to learn more about that issue. I don't know if you want to say anything more about that issue or move on.
Well, yeah, the only other thing I could say is that some of us had hoped that the recommended practice would incorporate the concept of materiality, that there are things for which it's not worth anyone's time to spend going back and forth with a cost share review, but that hopefully agencies will start doing that on their own accord.
So let's move on to the sixth item I wanted to discuss, and that's the right of first refusal. Now, the draft recommended practices, released about 6 months or so ago, contained a new section addressing this contentious issue. However, the recently finalized updated recommended practices did not include this proposed additional section. So maybe, Mark, if you could explain why this additional section wasn't included in the recent release, as best you understand it at a high level, and also where you believe NCSJ is headed with respect to a recommended practice on this matter.
So the initial draft, yes, had a fairly lengthy new section on right of first refusal, and it would have substantially expanded agencies' role in that process between the partners. And it would have done things like having them define what right of first refusal means relative to common law practices, would have been whether there was a need for a third party to submit an offer. And so policies along those lines for the agency to adopt it and put in their rules for how that worked in the state. And the Low Income Housing Tax Credit Working Group, among others, submitted in our letters the observation that having those types of expectations, those types of rules overlaid by the agency onto the right of first refusal process could have called into question what is meant to be a safe harbor in Section 42I-7 for how the ROFR works. And so while I certainly don't have inside information, I don't know for certain, my pretty confident guess is that the task force and NCSHA, upon seeing that observation from, again, the working group and others, that their proposal would have potentially called into question or even undercut the way Section 42 is meant to work, that they decided that it was not ready to be included in this document and that they needed to let the rest of the changes go forward. But as for what's to happen, I do know for certain that the NCSHA and at least many, if not all, nearly all of its members, are not done with this particular subject matter. They intend to continue working on it, maybe even to have another task force group that will have activity along these lines. And when that will take place, what they will do, of course, is to be determined. I can add, just as an aside, this is not the only subject on which that further effort will take place. There wasn't a proposal in the draft recommended practices about average income, but that is another subject matter on which the agencies will continue to work on potential draft policies. And so, in other words, the way that agencies implement the new minimum set aside of average income. And so that would be that, and right of first refusal are still on the to-do list, for lack of a better phrase, for the agencies going forward.
Well, thank you for that, Mark. And thank you for discussing these 6 changes, or I should say 5 changes and 1 future change. And there's obviously a lot more to review and know about the recommended practices and the updates. I would encourage our listeners to click on the link in the show notes and review the updated recommended practices. I'd also encourage our viewers and listeners to reach out to Mark if you have any questions or seeking more information about what we discussed today. I will include Mark's contact information in the show notes for this week's episode. And of course, I'll list the contact information for the other Novogradac partners and employees we mentioned in the course of the episode. But I did want you, Mark, to take a moment to share what additional resources our audience should know about.
So I wrote a blog post about this whole recommended practice change, so that with more information, so that is available with links. And one of the links within that you could look up on your own is also around the same time as when I was last on the podcast, was I wrote a 10-part series on qualified allocation plans, explaining how they work and what the important components of them are. Obviously, even a 10-part blog post series doesn't cover everything, but that has a lot of perspectives and information on what is, in my opinion, an understudied, under-examined set of documents, because they control 9 figures more of resource. Yeah, really more than 9 figures of resources around the country every year. And there's hardly anything out there available about them. So that's why I wrote that blog post series back then, to try to get some information and understanding about how they work.
Right. Thank you for that. And I would also layer in there that we do have our 2024 Affordable Housing Developers Conference coming up in Fort Lauderdale. So that'll be in January. So I'd encourage listeners and viewers to join us in Florida. Also, Novogradac does have a training platform. If you're not familiar with it, this training platform can assist the developers, their teams, investors, syndicators, underwriters, and the like, learn more about the law for the tax credit, compliance, tax, audit issues, and much more. So please email cpas@novco.com if you're interested in learning more about our training platform. We do have a number of clients that do one-off training on the platform, as well as some that get an unlimited subscription to various Novogradac trainings. So it's definitely a great opportunity to build out your own teams. So thank you, Mark. We've covered a lot of ground today. Please stick around for the off mic section. To our audience, I would like to encourage you to subscribe to Tax Credit Tuesday if you're not already a subscriber on your favorite podcast platform. That way you'll make sure you don't miss a future episode. And it's obviously also a way to have it downloaded on your iPhone or other listening device, traveling and the rest. And if you like the podcast, I'd also encourage you to review our podcast on your favorite platform or platforms. Then finally, as I say every week, if you have ideas or suggestions for future episodes, please email those ideas to us at cpas@novoco.com. So now we're going to turn to our off mic section. I have a couple of fun questions for you, Mark. Appreciate you staying on a little bit longer. The first question has to do with a book recommendation. As my regular listeners know, I got back into book reading and listening during the pandemic. It's something I've continued with after the pandemic. So is there a recommended book that you think that I and or our listeners should be reading or listening to on Audible?
Absolutely. Blank by Malcolm Gladwell. It absolutely changes the way that you appreciate the way that all people make decisions and or react to the world. And it gives some amazing anecdotes about how experts are able to use their expertise in very immediate, quick ways. But if they're asked to actually explain how they can do that, not only can they not do it, the act of attempting to explain that makes them worse at it. What they're able to do is, because they're experts, because they've been doing something for their whole career, they can look at a situation and come to a rapid, immediate conclusion that's almost always right. One example that they gave was a tennis pro, and he could predict 19 out of 20 times whether someone was going to fault on their serve or not before it happened. There was an art expert who, as another example, that was able to look at a sculpture and instantly knew that it was a fake. No one had proven that it was a fake. It was supposed to be from ancient Greece, but he just knew, looking at it, that it wasn't real. But those same instant reactions that we have in our head can also be bad. They can also be based on prejudices and biases that can lead folks to come to conclusions that are not well founded and are not well grounded. And I'm really not doing an adequate job of it because it's a whole book. And so, but it makes you realize the extent to which we as people come to rapid, immediate conclusions that get locked into our head, and how, again, that can be good or bad.
And that's great. I'll add it to the list. I've heard lots of others speak highly of the book, so I'll add it to my list. My other question has to do with professional goals as we in 2023 head into 2024. It's a time for, setting various goals, New Year's resolutions, what have you. What's the professional goal that you have for 2024?
Well, I don't know this necessarily for 2024, maybe longer term than that. But what I would love to do before I retire, which who knows when that'll be, it'll be a while at least.
Hopefully.
is to export the housing credit program to another country. I've actually made some steps in that direction to England, and they haven't gone very far though, but that was just something that, like Canada, really needs it. There's so many of these other nations would do well to copy the housing credit program. A lot of them have their own good below market systems, usually often called social housing, but they don't go far enough, which is no surprise. And what we do in America with the housing credit program is uniquely successful because we use the tax code. And I just think it'd be really great for some other country to adopt that system. And of course, they would need a consultant to help them advise on how to get that done. And so we'd be there ready, available to provide that.
Well, that's a great goal. I appreciate that. Thanks for sharing it. I'll join you in adding that to one of my professional goals. And like you say, it may not be for 2024, but a professional career goal. So thank you for joining me, Mark. Let's not make it 2 years until your next appearance on Tax Credit Tuesday. And to our listeners, I'm Mike Novogradac. Thanks for listening.
This weekly podcast has been brought to you by Novogradac and Company, LLP. Archived podcasts are available online at www.novoco.com/podcast or by subscribing to the Tax Credit Tuesday podcast in iTunes, Spotify, YouTube, Google Podcasts, Stitcher, and Radio Public. You can find related links referenced in this podcast on our website at www.novoco.com/podcast. Novogradac and Company, LLP is a national certified public accounting and consulting firm with offices nationwide. Learn more about our professional services at www.novoco.com.